Warranties. If you're looking to buy or sell a business, warranties will play a key part in the sale and purchase agreement. But what are warranties? How can they be used strategically, and why should you care? In this video, we'll discuss just that, and the principles will be transferable to warranties that even come with consumer products. So what is a warranty? In an acquisition, a warranty is a contractual promise made by the seller to the buyer with the purpose of assuring the buyer that certain information about the business is true. So why is this relevant or important? Well, when it comes to buying a business, the English law principle of caveat emptor applies. Caveat emptor means buyer beware, and what that means for a buyer is that they are the ones who are expected to conduct due diligence on the business they're looking to buy to determine whether it is a good idea to buy it or not. This is different to consumer products, where there are legal rights of consumers to expect that the products that they are buying are, for example, fit for purpose. In practice, it makes the due diligence less costly, less extensive, and it minimizes the risks of the buyer. This is because instead of, for example, the buyer having to determine whether the company they're looking to buy has always paid their HMRC taxes, they can simply ask for a warranty from the seller stating that they have, and there's no money owed to HMRC. You should, of course, always try to check that that is the case. As lawyers, we advise our clients, if they are buyers in a business acquisition, to make sure that the warranties are extensive and comprehensive. If instead our clients are the sellers, we would negotiate on their behalf to make sure that those warranties are as narrow and as limited as possible. So let's look at some warranties in practice. So what kind of warranties would you, as a buyer, want to make sure that are present in the sale and purchase agreement? As previously discussed, we might want to make sure that there is a warranty that promises that the target company that is being bought has always paid their HMRC debts. If this isn't the case, the seller is unlikely to want to sign that warranty as is, and instead might disclose some information about the past issues, for example, that they've had with HMRC, and this will help them in qualifying that warranty, meaning avoid being sued. And this is an interesting point because buyers can use warranties to elicit or get the seller to share important information about the target business. I'm Malcolm Zoppi, a qualified solicitor and the managing director of GZ Legal. GZ Legal is a boutique corporate and commercial law firm that specializes in drafting commercial contracts and helping people buy and sell businesses. If you're looking to buy or sell a business, get in touch today via the link in the description below for a free legal advice call. So let's assume that you've appreciated the importance of warranties. You've included warranties in the sale and purchase agreement, which has now been signed. But it turns out that one of the warranties given by the seller was untrue. This is recognized as a breach of a warranty, and it may give you, as a buyer, the right to sue for compensation as a result of the losses that you may have incurred. So, for example, if it turns out that the company that you've bought actually did owe money to HMRC and now you must pay it, you may be able to claim that money back from the seller. Thanks for watching. Make sure to check out the rest of the channel, which covers a range of legal issues that are relevant for small businesses in the UK and buyers and sellers of businesses. If you would like a free legal advice call, make sure to visit our website, which is linked in the description below.